Hello everyone and welcome back to Emmy Law's YouTube channel, your go-to source for valuable insights on legal matters. I am your host, founder, and principal lawyer of Emmy Law, and today we are going to be diving into the corporate litigation and how to effectively handle disputes in property ownership and maintenance charges. Handling disputes in property ownership and maintenance charges within a corporate context does require, in all fairness, a strategic approach to ensure a swift resolution, while at the same time minimizing any potential damage to your business. First, it is important that you begin by thoroughly reviewing all relevant contracts, agreements, and documentation related to the property, ownership, and maintenance charges. This includes lease agreements, maintenance contracts, and all correspondence between the parties. When reviewing any of these documents and contracts, it is important to pay close attention to clauses outlining the party's responsibility, payment terms, and dispute resolution mechanisms, and legal provisions. You should also review any of the statutes that are related to your dispute. For example, in Ontario, we have the Commercial Tenancy Act, which owners of commercial property and leaseholders look to when dealing with a dispute related to, for example, rental of units and responsibilities of landlords and tenants, and so forth. You then also have condominium corporations and condo owners. They review the Condominium Act in Ontario, which defines and outlines their responsibilities. You should also review case law related to the dispute to determine how the courts have dealt with such disputes. If you are bogged down with any legal jargon related to the case law you review, there's always some snippets out there. There's always somebody, some lawyer, especially if it's a relevant case that just came out. Lawyers, law firm owners, students, everyone is running to that. We'll run to that case law, we'll review it, and write a little blurb as to how that case has been used. If your dispute is an issue that has never been dealt with by the courts, it is still important to be creative in your search and try searching for other similar legal issues. If you're still stuck, reach out to a mentor. For example, if you're looking at, if you're working with a lawyer, or this issue has it's new and no one's dealt with it, you might want to reach out to a mentor within your legal associations, and they'll be able to provide you with the necessary guidance on how to proceed. Once you've done all of that, then you want to communicate with the opposing party to start your negotiations. You should take steps to attempt to resolve your issues in a friendly way as possible through negotiation or alternative dispute resolution methods such as mediation and arbitration. Most likely, contracts that you do enter into and agreements will have clauses that are contained in those contracts that are associated with alternative dispute resolution. If not, it is still an option that needs to be considered. Clearly communicate your company's position, concerns, and desired outcomes while remaining open to compromise. You also want to consult with an experienced corporate lawyer specializing in real estate and commercial litigation to assess your legal merits of your case and explore any and all potential strategies. Lawyers do this by identifying any and all legal grounds for your position, including breaches of contract, negligence, or statutory violations. Then you want to consider sending a formal demand letter outlining your grievances and desired resolution. This can sometimes promote the other party to address the issue without resorting to litigation. It is important to know that not all demand letters result in the dispute being resolved, but it is a step in the right direction. It is important to explore the possibility of settlement negotiations, where both parties can reach a mutually acceptable agreement outside of court. As mentioned in my other videos, settlement discussions can occur at any point during your litigation process. Now, if all the efforts have been made to resolve the dispute out of court and the attempts are unsuccessful, you need to prepare for litigation. This involves collaborating with your legal team to develop a clear litigation strategy. Steps will also need to be taken to determine the appropriate jurisdiction and court for filing your lawsuit, and so forth. You will need to consider factors such as venue, legal precedents, and procedural requirements. As mentioned in my previous videos, evidence gathering is very, very important in any and all legal cases you will be involved in. Collect and organize all your relevant evidence to support your case, including the contracts, invoices, correspondence, photographs, audio and video evidence, witness statements, and so forth. You need to ensure that all evidence is properly authenticated and admissible in court, and your legal team will assist you in gathering that evidence and determining whether it's authentic and whether it could be used in your proceeding. You also need to adhere to court deadlines and procedural requirements throughout the litigation process. If not, you might not be able to proceed with a step in the litigation, and you will need to explain to your client why the deadline was missed. And, lawyers don't like to have these conversations, so it's important that you diarize everything. Present your case persuasively during hearings, motions, and trial proceedings, utilizing the expertise of your legal team to advance your matter and advocate on behalf of you in court. It's important that you remain open to settlement discussions throughout the litigation process, as settlements can offer quicker, less costly resolution compared to a full trial. Evaluate settlement offers carefully, considering the potential cost, risk, and benefit of accepting or rejecting the proposed terms. Now, if you're successful in litigation or settlement, ensure the terms of the resolutions are properly documented and enforced. Monitor compliance with any court orders, settlement agreements, taking appropriate legal action if necessary to address non-compliance. After resolving your current disputes, take proactive measures to mitigate any future risks and prevent similar issues from arising. This may involve reviewing and revising contracts, implementing stricter oversight mechanisms, or enhancing your communication channels. By following these steps and working closely with your legal professionals, your business can effectively handle disputes in property ownership and maintenance charges, protecting your interests and reputation while minimizing disruption to operations. Remember, today's information isn't legal advice. If you need personalized guidance, reach out to us at 416-606-5405 or by email office@melaw.ca. If you found this video helpful, don't forget to hit the subscribe button and the like button. We appreciate your time and look forward to seeing you next time, and hopefully we'll talk soon. Thanks. See you later.